So I'm going to say welcome to the first Return to the Vault podcast. This is a show where we're going to break down some trends and challenges shaping today's real estate. And today we're going to talk about the FinCEN residential real estate reporting rule. And we're here with Amy Zico from Fidelity, who's going to give us a great CLE on Friday, but we wanted to get some information from her before then. So, first things first, Amy, can you kind of explain what the residential real estate rule is?
Sure. It's a new regulation from FinCEN, as you said. It requires real estate professionals that are involved in the settlement and closing process, such as closing or settlement agents, to submit to the Financial Crimes Enforcement Network a real estate report for certain non-finance transfers of residential real property to legal entities or trusts.
And I know most people should know this already, but when does this rule take effect?
It begins on March 1st of this year. So it was delayed from December to March 1st. I think they delayed it in September, at the end of September. So it's coming up quick.
Yeah. And I think probably people are beginning to panic about it. And I think to me, one of the most interesting things is the reportable transaction is kind of a broad transaction. So can you explain to us what a reportable transaction is?
Sure. You're required to report a transfer if the property is residential, the transfer is without financing from a bank or similar financial institution. So non-financed, the property is transferred to an entity or trust, and an exception doesn't apply. That's pretty broad.
Yeah.
When you look at it in general terms.
Well, and one of the things you and I were talking about is kind of what counts as residential real estate, because it's a lot more than just people's houses or a townhouse. Are there specific things they should look for?
So I think the best place to start is first what the rule says, which is that it's any property that has a structure designed for occupancy of 1 to 4 families. But it also includes property where the transferee intends to build, so vacant land where the transferee intends to build a structure designed for occupancy by 1 to 4 families. They do say in the rule specifically that a unit designed for 1 to 4 family occupancy within a structure on the land is residential real property, as are shares in a cooperative housing corporation. The rule itself doesn't go any further, but they have given us some guidance in that apartments can be considered residential real property if they are for 1 to 4 family. As you said, townhomes, condominiums.
Yeah.
It wouldn't be a large condominium building that would be considered multifamily that's more than 1 to 4 family, but a unit within that building, if it's just a unit, would qualify, or a condominium that is only 1 to 4 units, the whole building might qualify.
What about, do you know about developers who are building a subdivision? If they're buying that parcel to subdivide, does that count as a residential real estate?
Yeah, so that one gets a little bit more sticky in that you've got to look at the intent. And they have tried to explain in the most recent release of their FAQs. So I will say, please read those on the FinCEN website, because I think it's still subject to a little interpretation. But
Okay.
I would say, yes, it can be if the developer is going to retain any of the land while the 1 to 4 family structures are going to be built. Or, if they have the large parcel of land and they're going to develop even one structure, 1 to 4 family structure on that land. So again, it goes to their intent, but you want to be careful to understand your specific transaction and exactly what's happening in it.
And I would guess probably just to begin with, going wider is better than going narrower for people who are unsure.
Absolutely. I would err on the side of caution in any gray areas.
Now, this is kind of linked to that idea of geographic targeting orders, correct? Like, is this just kind of specific areas of the US, or this is everybody?
This is everywhere. So they've had the geographic targeting orders, not in North Carolina, so most of our attorneys aren't super familiar with them, but they've had those since at least 2016 in major metropolitan areas. those have some limitations. In addition to area, they have a threshold.
Okay.
Here, we're talking about anywhere in the U.S. territories, Indian lands, and there is no threshold.
So even if it's a gift, it counts.
Correct. $0, it can still be a reportable transfer.
Oh my gosh. So this is going to cover a lot of people maybe that they didn't originally think. Um, what is a non-financed order? Because I think that's probably also a trap for the unwary. It doesn't just mean cash sales, does it?
Right. So non-financed is any time where the purchaser is purchasing the property and it is not going to be financed by a bank or other financial institution that has anti-money laundering and SAR reporting obligations.
Okay.
So it's two-prong. It has to be secured by the property and be financed by a bank or lending institution with anti-money laundering regulations to be considered financed and therefore not reportable.
So that's going to include private lenders or hard money lenders or investors. All of those things could
Seller
be
financed.
seller
Yeah.
financed. Okay. So that's a trap for the unwary right there. Who is actually in charge of filing the reports?
Right. So FinCEN, their ultimate statement is that it's the settlement agent or closing agent, but the rule has a reporting cascade. So you start at the top with the one that's listed first for the transaction, and then you move down the list, and the top is the settlement agent or closing agent. The second is the person who prepares the closing or the settlement agent if one is not listed on the closing statement itself, and so on and so forth. And we can go through the list, but in North Carolina, it's most likely going to be your closing attorney because residential real estate closings in North Carolina are typically handled by our North
Correct.
Carolina
Yeah.
attorneys.
Yeah. So what information do the attorneys have to report?
So the reporting requires you to report first who the reporting person is and where they fall in the cascade, and just a little bit of information about them, which I haven't tried or looked or seen if that's going to automatically populate most of it if you're
Yeah.
already logged in because you're using your ID, but you would think that it would. So the reporting person, the property information being the address and the legal description, the transferee entity information or trust information, including their beneficial owners information and authorized signers. That's going to be addresses, office addresses, taxpayer identification number for the entity or trust information, address, taxpayer identification information for the beneficial owners and your authorized signers. What am I leaving out? The closing date and the payment information, including any third party payments that are made on behalf of the transferee entity or trust if money's not coming in from them, and if money comes from a bank, the bank information.
Okay. So it's a lot about who the people are in the transaction and some of the information the attorneys already have.
Right. It's who the people are and where the money's coming from
Yeah.
to a certain extent.
Yeah. Now I know the big question is about exemptions. Are there transactions that don't count? I I thought it was interesting on the updated FAQs on the FinCEN website. They talk a little because originally there was kind of a discussion about an exemption for 1031 exchanges. But I think they clarify on the website now that that's the transfer to the qualified intermediary and not the qualified intermediary to a transfer entity or trust. But that was kind of news to me when I read that FAQ.
Yeah. So, and the reason being is that that transfer is it's because of the entity itself that's taking title. So your exchange accommodator entity is more regulated and less likely to be a bad actor.
Yeah.
So that was the reason for clarifying that.
Well, there's a lot. I mean, it's interesting because there's kind of broad exemptions, but then when you dial down into it, they get a little more narrow.
So you have transfers themselves that are exempt, but you also have exempted transferee entities and exempted transferee trusts. So you've
Okay.
got a couple of different ways that your transaction might not fall within it. But most of the exempted entities or trusts is because they're a regulated entity, like banks, credit unions, things like that. 1031 exchange companies.
Yes.
So the ones that are not reported is a transfer or grant of an easement
Okay.
or a revocation of an easement, a transfer that results from the death of an individual, whether that's by will or joint tenancy with right of survivorship or operation of law, intestate succession, or contractual provisions,
Okay.
such as a beneficiary designation. Also, a transfer that's incident to divorce or dissolution of marriage, transfer made to a bankruptcy estate, a transfer that's supervised by a court of the United States. One question that has come up on that is, well, what about foreclosures?
Yeah.
Um, I don't think it exempts your transfer to a third party purchaser
Okay.
in a foreclosure action. I think your transfer to your bank would be because of the entity that they are and not necessarily
Yes.
because it's supervised, just because of the way that foreclosures are done.
Sure.
At least our power of sale foreclosures.
Okay.
But you've got third parties bidding in, and there's no vetting process of those third parties. So I
So
don't
that would
think
kind of
that those would be considered exempt. That's my opinion. I don't think
Yeah.
I didn't look to see if they have a
yeah.
FAQ on that yet, but
And there are a lot of
I-
I mean, they updated the FAQs, and there are a
They-
lot of answers now.
they did, which is good. We need
Yeah.
more answers. We need more guidance. A transfer for no consideration made by an individual, either alone or with their spouse, to a trust of which that individual or the individual spouse is the settlor or the grantor. So if you are conveying to your own trust, then that transaction would be exempt.
Okay.
But if you bought property in the name of that trust,
And it may
it would
not
not
be.
be. It may not be exempt.
Okay.
A transfer to a qualified intermediary for 1031 exchange, that's only the transfer to the exchange accommodator, not the transfer out to the ultimate entity. That might be reportable. And then a transfer for which there is no reporting person, and that's always
Yeah.
one dimension. And then everybody goes through the cascade trying to figure out when that
Yeah.
would happen. And I think that's mostly, for instance, if your client prepares their own deed and records their own deed, they're not a reporting person because they're not a financial institution subject to the rule.
Okay.
So I wouldn't, you know, that is not necessarily something you want to guide your
Yeah.
clients to do. Pull deeds off of the internet
Yeah.
and record them. We know what kind of problems those cause. But
Yes.
if they do that, if they ask you about that they are not a reporting person. So
when grandma gives to grandkids trust, that there may not be a reporting person in that transaction.
right.
Yeah. Great. So, I mean, I guess the big question is, what do our attorneys need to do from here? Like, how do they get ready for the March deadline?
I think that there are a couple of things. One is making sure they know how this is going to fit in their workflow. Like, who's going to be their point person for all of this? And
Because it may
Before the
change their workflow.
yeah, it may. And I caution them, this is not a collection of data you want to do at the closing table. There are collection forms, there are manual collection, paper forms. There are also ways to collect data. I know SoftPro's working on one that can be sent to your customer, your client. I think Qualia also is. And then there's third-party vendors that will also assist with that. That's outsourcing. You're still the reporting person. If a third-party vendor helps you with the process of collecting and reporting. But you need to figure out how you're going to do that, because you have to collect the data first, and you have to have it to be able to report by the 30 days after closing or the end of the month following the last day of the month following the month of closing. So For instance, if you closed on March 15th, you would have to report by April 30th.
What do you think the most important thing is that real estate attorneys need to know about the new rule?
That it has to be done.
Okay.
That there's no I mean, I think that's the most important thing to accept at this point. It doesn't look like they're gonna delay it again. It
Okay.
doesn't look like it's gonna go away, at least not yet.
Yeah.
We can all hope that it might, get some limitation or whatnot, but that it's not going away and that reporting is coming up and you cannot file a incomplete report.
Okay.
And there are penalties if you don't
Yeah.
file. So I think it's important to recognize that it's time to get
Moving.
prepared and figure out your process. And they can go ahead and enroll on the Bank Secrecy Act website
Okay.
where the e-filing is done. The e-filing yourself on that site is free. There's
Okay.
no charge for that. So if they want to do it themselves, they can. It's directly through the site on either an online form submitted directly through it or a PDF completed and then uploaded.
Okay.
And it's
So
for each transaction.
yeah, so if they don't wanna pay a third party, they can do it themselves.
Right.
Just
And they
submit it.
can charge for it.
Okay. Oh, okay. That makes sense. Yeah. Wonderful. Well, I appreciate it. I appreciate you answering all our pressing questions, and I'll put in a pitch for the real property section hot topics CLE on February the 20th. Thank you.